Good evening, Vishal sir. It is an honor, truly an honor to have you on the show.
Good evening, Akash. Good evening.
So, sir, please can you do us the honor of introducing yourself?
Yes, I'll do that. So my full name is Vishal Aggarwal. I'm a legal associate. I'm working in the legal field since last 4 years. I am an economic honors graduate by background. I started my studies with economic honors from Delhi University. After that, for some reason, I got pulled into law. And since then, I have a great affinity towards law and practicing typically in the dispute resolution. And apart from that, I also have a very good predisposition towards international arbitration. That is something that I've studied at master's level, but we can deal with that later. But I definitely do hold a lot of interest in international disputes, and I work really a little bit in international disputes as well. And apart from that, I make sure that I'm involved with some of the initiatives which are related to international arbitration as well.
Right. So,
Yes.
sir, before starting anything, I would like to ask you, how did you end up in law?
Yes, so that's an interesting story actually. After completing my schooling, actually, I was always an economics student. I was someone who's always interested in economics, and that's at that point in time I had options of either going for law or either for economics. So I chose economics because I always had a passion for economics in 12th. So I started for economic honors, but once I completed my economic honors from Delhi University, I again was faced with two choices, either to continue in economics or go down the path of law. So it was actually because of my father who suggested, why don't you give a hand at law for 1 year? If you don't like it, then you can come back to economics. So I started with my 3-year law. And when I started, I actually liked a lot of reading case laws and making arguments. I immediately started participating in a lot of moot court competitions, and I actually won a lot of accolades in those competitions. So I finally thought that yes, I'm fit well for this profession, and as slowly started gaining more interest in the field of law, and I thought yes, it was the right decision to step into law. So that's how accidentally from an economics student I came about being a law student and a law professional eventually.
Right.
Yes.
So you also have a lot of practice in ADR and you are very interested in it. So what made you gravitate towards it?
Well, to be honest, you see the situation of the Indian judiciary and the Indian court system right now is in a very pity state, is in a very sorry state. You see that there are about 4 crore cases pending in the courts. So, of course, the ultimate alternative that is there to the court litigation is ADR, alternate dispute resolution. So I thought, let me start focusing on ADR because that is something that is definitely the next big thing in India. People are gravitating towards ADR to resolve the disputes faster at a cheaper cost. So I thought, let me start looking into what these ADRs are. And this is the time period when I was just graduating and I had newly developed interest in ADR. So I started with arbitration. I was actually being involved in some of the arbitrations being held at Delhi International Arbitration Center, which is DIAC under the AGs of Delhi High Court. So I was working in arbitration, and I thought it's an excellent mechanism. I saw that how dispute resolution as compared to a civil suit can be solved at a very fast pace in a very frame or set of manner of rules, and there's something you see that a private tribunal can adjudicate your disputes at such a fast pace, and obviously it's exact replica of litigation, but you see there are benefits associated with it. So I thought, why not? Let's just try our hand in arbitration. And that's how, right from domestic arbitration, I developed that interest. And then later, my interest got expanded into international arbitration as well.
So as you say that the courts, the cases in courts are getting piled up, so arbitration field is growing. So would you say it is lucrative for aspiring lawyers?
I think lucrative is something which is a very subjective thing, but yes, definitely from the amount of practice point of view, I see that arbitration is going to grow very quickly and very prosperously in India, because we see a lot of new contracts, including arbitration clauses, in the alternate of going to the courts. So we definitely see a lot of arbitrations up and coming in India. We see arbitration practice going in India, and that is the reason that we saw now that we see now, in fact, that there are a lot of lawyers who just specialize in arbitration rather than doing
Right.
any other thing. And in fact, it would be surprising for you to know that arbitration is just the dispute resolution mechanism, it's just a procedure. And in spite of that, we see lawyers who are just doing arbitration and not doing anything else. And that is itself an evidence that you see arbitration being the next big thing in India. And in terms of being lucrative, see, it depends upon the value of arbitration that you're involved in. So lawyers who are involved in big shot arbitrations, which involve claims of crores rupees, obviously their fees is proportionately high in terms of that. So that is again lucrative. But in terms of having opportunities in working in the field of arbitration, I feel that everyone would get a very good amount of chance to work in this field. And arbitration is definitely a next big thing in India.
Right. Okay.
Yeah.
So, sir, would you explain to the lay people what arbitration means and how is it different from conciliation and mediation?
Right. So, as far as arbitration is concerned, I pretty much assume that everyone knows about how exactly a court litigation goes about. There is a plaintiff and there is a defendant. You plead your case before a judge, and then the judge gives a ruling. The similar kind of adversarial process is something which is followed in arbitration as well. You also have there in arbitration as well, you have a claimant and a respondent. Claimant is the one who is making the claim, and the respondent is the one who is defending the claim. The only difference between court litigation and an arbitration is that you do not have a court appointed person. So basically, sorry, not that is a wrong thing to say. You have a private tribunal, you have a private dispute redressal person who is going to adjudicate your dispute. So you do not have to go to the court for that. So the entire mechanism of arbitration gets its force from the point that it's private dispute resolution mechanism. It's not something for which you have to rely on courts. So it's because it is private, and parties have the autonomy to control it with their choices. It's much faster. So in short, to say it's like a private dispute resolution mechanism, but it is totally detached from courts. So parties have a much more flexibility in terms of controlling the procedure. And obviously, it's just like court litigation, it is adversarial, and there is going to be someone who's going to be adjudicating your disputes. So here you draw a fine line between arbitration and mediation and conciliation. In arbitration, there is an adjudication of dispute. There is a tribunal who is going to adjudicate, who's going to listen to the claimant, and who is going to listen to the respondent, and he's going to adjudicate the dispute, which dispute is right for the claimant, which is wrong. But in mediation and conciliation, this is not something how it goes about. So in mediation, you have two parties who mutually wants to come together to the table. They want to sort out their differences. They want to see what exactly is the middle ground to the problem that they're facing. And as far as conciliation goes, there is a third party involved, but that third party is not there for the adjudication of disputes. In conciliation, there is generally a person named as conciliator. So he helps the parties bring them to a middle ground, and he kind of conciliates between the two parties. He gives his neutral third viewpoint, but that is not something which is adjudication. That is just giving a view that this is the middle ground, I think, which is between you, in which you two can agree on, and this is the conciliation, the entire proceedings, and I can help you bringing you to a final solution to the problem. So there is no adjudication as far as mediation and conciliation goes, but in arbitration there is an adjudication process.
So in arbitration,
I hope that clarifies.
Yes. So the person who's appointed to adjudicate the dispute in arbitration, is it necessary that he has to be from the legal background?
Well, that's a very valid question, to be honest. Technically, no. So because we see arbitration can be in different areas of law. For example, I will give you an example and explain you. For example, you are working in a construction field. All right. So you have construction people, parties who are related to construction. All right. So in there, an engineer who is a civil engineer who is generally involved in construction process, he can too be an arbitrator. He can
Right.
act as an adjudicating authority because he understands the crux of the matter. He understands what exactly is the dispute between the parties. He understands what are the technical terms which are involved in the construction, and what is the material about, what is the process where the process has gone wrong. So civil engineer has that knowledge in construction field, so he can be an appropriate person. But with that caveat, generally what happens, a person from a legal background is being appointed as an arbitrator only for the sole reason that the parties generally do not plead their cases, but it is the lawyers who plead their cases of the parties. So
Right.
there has to be someone who has a legal knowledge as well, who is, and that person who has the legal knowledge is obviously is from a legal background. So that's
Right.
why the circle comes around, and we always find people from the legal background being appointed as an arbitrator.
Right. Sir,
Right.
suppose you and I are in a dispute. Okay, so
Yes.
like, can we go straight to arbitration, or do we have to go through the process of mediation and conciliation as well?
Right. So I think this is again a very important question for someone who wants to know how exactly this area works. So in area, there are generally, so first of all, it totally depends upon the contract, what is written in the contract between you and me.
Right.
So obviously every contract contains a dispute resolution clause. So that dispute resolution clause is actually something that is going to define how we're going to progress in terms of any dispute arising among us. So when you talk about going in a stepwise manner, there is something called as multi-tier dispute resolution clauses. So when you have that multi-tier dispute resolution clause, it generally defines what are the steps in which you can progress to arbitration. So for example, you have a two-tier multi-dispute resolution clause. In tier one, it says that you need to have a mandatory mediation before going to arbitration for 30 days. So if it
Right.
says that, if you and me enter into a dispute on any given day, and then as a first step, we would have to enter into mediation for at least 30 days and try to resolve that dispute through mediation.
Right.
Unless and until we do that, we cannot actually directly go to arbitration. So this is something called as multi-tier dispute resolution clauses. And you find these clauses often in a lot of contracts because parties want to make sure that they don't just start being acrimonious towards each other, adversarial towards each other. They want
Right.
to try to resolve the disputes
Right.
amicably first. So to make sure that the relations among them do not get acrimonious at the end of the day. So for this reason, these multi-tier dispute resolution clauses are inserted. And
Right.
yes, in certain cases, you see courts saying that you had this multi-tier dispute resolution for a reason. So you had to first try to go through mediation, which is the first step, and then only you could have gone to arbitration. So in some of the cases, it has been upheld that it is actually very important for you to go through the entire procedure and not just jump ship and straight away go to the
Right.
arbitration.
Right. So, since you said that arbitration, dispute resolution is a means of saving time, it is better in saving
Right.
time than judicial system. So, would you say
Right.
that it is overall a better process that parties should resort to it first?
Well, I'll be biased because I am practicing in
Right.
arbitration, so I'll definitely say arbitration is a better mechanism. But let's just have a bird's eye view of it. So we can compare apples to apples and oranges to oranges in the
Right.
sense that you see that amount of time being consumed in a civil suit in a court with an arbitration. You definitely see arbitration being resolved in a period of 1 year, 2 years at max. And on the top of it, if you have an arbitration clause and you go to arbitration, the plus side of it is in the act itself, in the 1996 Act of Arbitration, you have a time period defined, which has been included within the recent amendments of the act, that you have to complete the arbitration within a certain period, which is 1 year. So
Right.
that is something that provides a tooth to this speedy resolving mechanism of arbitration, that you have to resolve the dispute within a particular set of time, which is defined in the act. While when you go to a civil suit in a civil court, you don't have any such provision. So parties tend to drag on the civil suits for
Right.
years and years, and that definitely leads to a lot of cost and your time being consumed at the end of the day. So if you have a bird's eye view of the two processes, you definitely will realize yourself that going into arbitration is much more efficient than going into a court proceeding in a civil suit. So from that, coming from that background, I think definitely arbitration is much more efficient and effective as compared to normal court litigation.
Right. So the
Yeah.
award given by the arbitrator, is it binding and can it be appealed?
Well, yes. So appealed, when you say appeal, is used in a very different sense. So
Okay.
someone who is practicing in arbitration and someone who knows a little bit about arbitration needs to know there's something, there is a difference between an award being set aside and award being appealed. So when you say
Right.
use the word appeal, mean like in a civil suit, like in a civil case, the higher court can actually see what the merits of the dispute and see whether the lower court has actually decided it correct on the merits of the dispute. But in arbitration, if an award is passed by the arbitrator, there is no appeal. There is no mechanism of appeal. If you see section 34 of the Arbitration Act, there is a mechanism for setting aside of the award. And then section 34 also enlists the grounds on which you can actually set aside the award. So per se, there is no appeal because the courts who are supervising the arbitration did not set as an appellate authority. So they cannot see what was the reasoning of the arbitrator. They cannot see how the merits of the dispute has been decided with the arbitrator. Courts tend to not interfere with the awards in that sense. So they do not set as an appellate authority. But if you talk about whether the award can be set aside, yes, definitely it can be. But there are certain grounds on which the award needs to be challenged. And those grounds are something which are mentioned in section 34 of the Arbitration Act.
Right.
So when you say appeal might be a wrong word to use here, but yes,
Right.
awards can be set aside.
Right. So when there is a
Yeah.
miscarriage of justice of sorts, so usually in traditional courts, people appeal. So in this instance, under 34, will people be able to argue, plead their case, why to set aside the award?
Absolutely. So if you see section
Right.
34 to A talks about certain grounds wherein there was no due process of law. For example,
Right.
one of the parties was not given fair opportunity to plead their
Hmm.
case, or whether the party was not given due notice of arbitration.
Hmm.
So in such cases, what happens is that you can go to the court. Once the arbitration has been concluded, you can go to the court and say that I was not given proper notice, I was not given enough opportunity to plead my case, there is a miscarriage of justice, and then obviously this award needs to be set aside. So on that reason, award can be set aside if there has been a breach of the fundamental principles of law and due process has not been followed. You're
Right.
right. Yes.
Right. So are there any circumstances where resorting to arbitration may not be a viable recourse?
Uh, well, actually, yes, that's true as well. So
Right.
not everyone prefers arbitration because, see, the thing with arbitration is arbitration can be binding very quickly, and courts are very strict and stringent in terms of enforcing arbitration awards.
Hmm.
So if you're trying to uh, uh, prolong the litigation, if you want adversarial tactics where you don't
Right.
want to have a decision too quickly,
Hmm.
or for that matter, if your dispute is about a matter which cannot
Right.
be arbitrated, then in those cases I would not recommend you to go to arbitration. For example, there are certain cases, although arbitrability is another concept which we're going to take another altogether different session, but arbitrability basically means what matters can be arbitrated, what
Hmm.
matters are allowed to be arbitrated in India. So that
Hmm.
scope of arbitrability is being expanded every day with the court. But there are certain disputes, for example, matrimonial disputes. Those
Hmm.
disputes are something which cannot be decided by a private tribunal, because those are the disputes which affects the society at large.
Hmm.
So those jurisdiction for deciding those disputes has been vested with the courts, and in
Hmm.
no manner jurisdiction to decide those disputes can be given to a private tribunal. All
Hmm.
right. So if your
Right.
dispute is about such matter, which is against the society, criminal law, family law, then you cannot go to arbitration. That's
Hmm.
one point of view. And another point of view is in those cases where you think you want to drag the matter for a long time, or
Right.
you want to have those adversarial tactics in your pocket, and you want
Yeah.
to make sure that the other party suffers out of it, and
Hmm.
you do not want a quick decision, and then obviously arbitration is not something which suits you, because arbitration is going to be resolved quickly, and an award can be quickly executed with the help of the court. So in those circumstances, I would definitely never recommend you to go to arbitration in the first place.
But if it is written in the clause, then you are supposed to go, right, in the contract.
Well, if it is written in the clause, then it's up to the
Right.
other party. Obviously, if the dispute resolution clause says that you have to go to arbitration, then if you go to the court, then if the other party is smart enough, they're going to get a stay order from the court,
Right.
and they will force you to go to arbitration. And if you don't go to arbitration, they start one-sided ex-party arbitration. They will get an award against you, and that would be equally even more harmful for you, because then they would have an award where you haven't even pled your case.
Right.
So they have an award against you, and they can just go to the court and say, see, I have an award. I want this award to be enforced against this party. And then you would not have any case to make in front of court, because you yourself did not participate in the arbitration. So you cannot go to the court and say that I did not get a chance to plead my case, because you surrendered that right moment you did not participate in the arbitration, right? So again, it's a very factual thing. It would have to be seen whether you want to delay the arbitration for some reason. There are tactics involving that as well. People do that. And whether you want to participate in the arbitration and then challenge something. There are different types of tactics being involved in arbitration. You have to see what you can pick out of your sleeve and use it as a dialectic tactic, or whether you want to be sincere enough and fight your matter on merits before the arbitrator.
Right. Okay. What was your experience studying LLM in London School of Economics?
Well, it was a wonderful experience. I must say that the teaching in UK universities is contrastingly different from how the law is taught in India. Well, I've studied my bachelor's in India, and then I've studied my master's in UK. So the way they teach you in UK is extremely different from how they teach you here. There is no, first of all, of course, I'm not going to shy away from saying there's no cramming of anything in UK universities. They want to make that habit of making an argument, analyzing what is being put to you, and then give an answer. They just don't want you to memorize the case laws and give you give an answer. They want you to make an argument, even if that argument is wrong. They don't scold you for that, but they want you to develop that analytical ability to make an argument on the point of law. So, and that is how you actually become a good lawyer, when you start making an argument on the point of law, on the point of facts. You start analyzing what the facts before you, and then you start making arguments. Because obviously the laws and the law which is written, the statute and the case laws is already there. That is for you to assist, but that is itself is not the crux. You have to make use of them in your arguments. That cannot be your arguments. All right. But in my experience, I took a variety of subjects. Actually, most of my subjects were related to international disputes. Some were related to conflict of laws, and some of the subjects were related to competition law. So I had a mixed bag of international dispute subjects and conflict of law subjects. But the teachers were fantastic. They had they make sure that we are well equipped with all the resources. They were never shy. They were never shy enough from helping us with the tutorials, or if there is any other help which is needed outside the classrooms. And the classroom in itself, the people who comes to study in these colleges, it's fantastic. The atmosphere that you sit in these classrooms, you see everyone thinking on their feet, giving answers, and it's a fantastic environment to study. It was a wonderful experience.
Right. But it might be a little expensive, right? Studying abroad.
Yes, so it's obviously studying abroad has its pros and cons, and at the end of the day, you have to see where does your master's fit in, how can you finance it, how you're going to make returns out of it. That is extremely important, because you can't just go blindly and do a master's, which is going to cost you a lot. But you have to make sure that you have something in mind how it's going to help you and how you're going to make a return out of it. So yes, it is expensive. Doing a master's from UK is expensive, and I think everyone should have a careful analysis of pros and cons before they venture into this thought of that they want to do a master's from UK. Yes.
So if we talk about UK only, so can we be dependent that the college can provide us placement after LLM? and we can get a PR
Well,
maybe.
to be honest with you, sorry, did you ask for PR at the end?
Yeah, if after placement you can expect a PR maybe after some couple
So
of
when you
years.
say, sorry, just to clarify, when you say PR, what do you mean by PR?
Permanent residence.
Oh, that's a very far-fetched thoughts of Indian students, but they cannot write the life script for you. You're just studying in their
Right,
colleges, all right? So the assistance with the college provides in UK
right.
is extremely limited. I'll be very brutally honest with you, and all the people who are going to be viewing our
Hmm.
podcast as well. See, the assistance which all these colleges provides in UK is extremely limited in the sense that you can tap on the resources which they already have, and they
Hmm.
help you network, but they don't give you everything on the silver platter. That's not how it works in UK universities. And I'll be honest with you, and I'll burst this myth of a lot of people. These people, these universities, they have their career departments, but there is no placement cell. There is no such thing as placement cell in UK universities, because people who go from India to UK universities, they have a myth in their minds. They have this preconceived notion that the universities have a placement cell and they're going to help us secure a job or something like that. It does not work like that. They organize fairs, job fairs, which they do because of their networking. And
Right.
you yourself in your individual profile can contact the recruiters in those fairs and sell yourself, in the sense, if they seem that it seems to them that you are suitable candidate for them, they will sign you up. If it doesn't work like that, then it doesn't. There is no other third way. Either that, or either you network in your individual capacity
Hmm.
outside of college. If you can do that, if you're good enough in terms of networking, that is it. That's all how it happens. As far as permanent residency goes, I don't think so in any university of the world they're going to help you with permanent residence, let alone UK universities.
Right.
Right. So obviously everyone who goes to UK, they have a somewhere at the back of their mind, they have this thought process that university is going to help them with job placement, but
Hmm.
they have to be wary of the fact that there is no placement cell in UK
Hmm.
universities. They do help you, but their assistance is limited to the extent of their networking, and they can bring you closer to the recruiters. They can help you in CV building exercises, which is extremely important. They can help you with
Yes.
cover letter exercises, but that is it. After that point in time, it is you who alone has to venture out there, who has to secure jobs, who has to secure internships, and that is all. That's how it works. That's the plain truth. That's
Hmm.
brutal honest that everyone has to accept who has
Right.
made a decision to go to UK university.
Yes. So one has to take this into consideration as well after taking maybe a loan for studying abroad.
I think it's extremely important. I think it's
Yeah.
extremely important for you to counter and factor this into your calculations and your understanding of how you're going to pay back your loan. Because
Hmm.
if you're taking a loan for about, let's say, 30 lakh rupees, and then
Hmm.
you don't secure anything, you don't secure an internship or a job at the end of the day, you would have to see how you're going to pay back that loan, because that
Right.
loan is not going to pay back itself. So you have to see, UK market is extremely competitive. It's
Hmm.
extremely competitive. It's like a melting pot. You see a lot of European lawyers coming into UK to practice law. You see American lawyers coming to UK. You see Indian lawyers going to UK. So it's not that it's just a single market. It's like a melting pot. People from all the places are coming to UK, and then they have their own indigenous population, right? You have UK students who are studying
Yes.
in UK, and they also graduating every year, and they are also entering into the same market in which you are going from outside to compete.
Hmm.
So you see the amount of competition there is, and you have to compete among the best to secure something. And
Hmm.
if there is a vacancy, there are already 100 applicants who are much more equipped than you. So they're applying for the same position as you are, and they are more qualified. So you
Right.
have to see and factor in all these considerations before you think that no, I can just go there and I'll make something work. It doesn't work like that. It's extremely difficult. It works for some people, but it doesn't work for a lot of people. So you have to see both the sides. You can't just focus on the positives and see that no, if it happened for that person, it will happen for me as well. It does not work like that. So
Right.
yes, that's the plain true honest thought
Right.
that I can share.
Okay, so moving on to the subject of subjects, what can one look forward to when studying international relation for arbitration?
International relation or international disputes?
International disputes. Yes, international
Yes,
disputes.
right. So,
Right,
see, you have a lot of different subjects when it comes to international disputes. So, international disputes is actually a broader subset of a lot of different species of disputes. So you have international arbitration, which can be a commercial arbitration, and which is just a commercial contract between two parties, and then they have an international dispute out of
right,
arising out of that contract. Then you have investment arbitration, which is something which is again a very niche area, and which is something which involves an investor investing in a state, and then state has violated the rights of an investor, and then investors suing the state under a bilateral investment treaty, and that is
mm,
again an international arbitration, and that is again falls under the subset of international dispute. So that is something called as investment treaty arbitration. So that's again one species of international disputes. And then you have different disputes under Sale of Goods Act, International Sale of Goods Act. There is an International Sale of Goods Act. You can have a court international disputes in sense of public international law. For example, two states going to ICJ, International Court of Justice, to resolve their disputes.
right,
But that is a tranche of law which falls into the public international law,
mm,
where you study about conventions and treaties between the states and the countries, and then you help with one of the team who is representing one of the country before ICJ. So that's one another kind of international disputes. Then you have trade disputes. You have a WTO appellate body, that's
mm,
World Trade Organization. Then every country is generally a part of trade agreements,
right,
and then you have disputes before a WTO appellate body. You
mm,
go before the WTO appellate body, and then you see that my tariffs. I mean, I'm not very privy to all these trade concepts, but there's a dispute mechanism before WTO as well.
mm,
And obviously there is a lot of advisory work which goes into international disputes as well. For example, there is a lot of concept of conflict of laws, which court has a
mm,
jurisdiction if two parties
right,
enter into a contract which is international contract. So which court has a jurisdiction, which would be the governing law. So these are the different species which fall into a bigger subset of international disputes, and
mm,
then you would have to actually at the end of the day decide whether you want to do a part of all of these, or whether you want to specialize in particular of public international law, whether you want to specialize in commercial arbitration, or whether you want to specialize in investment treaty arbitration or trade disputes and before WTO.
mm.
So these are some types of international disputes that one can expect when they are trying to specialize in international dispute resolution.
Right. Can you
Right.
share some of your valuable insights or experiences working in international arbitration cases in London?
Definitely. In fact, so as and when I completed my, even before completing my master's, I actually got
Right.
an opportunity to work with a city law firm called Withers Worldwide. It's an extremely,
Mm,
it's an extremely big law firm, but somehow the partner at that law firm had a personal connection with me, so he gave me an opportunity to work in an investment treaty arbitration case, wherein we are representing one of the uh, Chinese investors against an African state.
mm,
So I worked with there, and I was part of the investment treaty arbitration team, and we were writing the claim for the claimant, and it was a wonderful experience. The way the team works, everyone makes you think on your feet, and they help you if you're stuck somewhere. They come to your rescue. They help you have a bird's eye view of things, and it's a wonderful feeling to be part of such a big project when you see such a big team working on a one particular case, because these investment duty arbitration cases tends to be extremely huge. They run into
mm,
millions and billions. So,
mm,
and there's a lot of documentation which is at play here. So you have thousands and thousands of pages coming in as documents. You have to filter those documents to see what
right.
documents are useful to you, what documents are not useful to you.
Yeah. The video has frozen. Just, yeah, you were saying.
Yes, so I was just saying that the person who is at the top is actually responsible for making sure that everyone feels part of the team, and they are making a contribution to the team and not just
Right.
being there with the
Hmm.
team. So that's extremely important, because when you're part of such a big project, every bit helps.
Yes. Yes.
So yes, that was the first experience with Withers Worldwide. After that, once I completed my master's, then again, and fortunately or unfortunately, I was working again with a city law firm. And
Hmm.
there again, I was working on investment duty arbitration cases. Therein, I was working with the team who was representing Iranian investors against the Republic of Korea. And again, the actually what happened there was that the state was challenging the award before the English courts. So
Hmm.
we were helping the investors with making their case before the English courts that the award should not be set aside. Award is a valid award.
Right.
So that involved working in an arbitration as well as working in English High Court,
Hmm.
and we had 5 day hearing. So how it happens in English High Court is that you're assigned certain days, and all on all those days you have a full day hearing right from 10 to 4, and then you sit for the entire day in the court with the lawyers, with the counsels, and with the judges, and then you each side make their cases depending on how long they're going to go on. So it was again extremely wonderful experience and an extremely delightful experience for me. I'm sitting with the counsels, strategizing how we should go about making our arguments, what should be our case laws and what should not be our case laws.
Right.
So yes, it was again a wonderful experience for me.
Right. The corporate culture was very good.
Yes, corporate culture is one thing, but the quality of practice is extremely
Hmm.
good. The way they argue, the way they think, the way they make you think, all these things, the quality of what they draft, that is extremely good. So you learn extremely good drafting there. That's there. So yeah, in overall, you learn a lot of things from the
Right.
English practice of law, and I got an opportunity to work with two good law firms. So that was extremely vitally important for me.
So, does having multi-tier qualification, like qualification from different countries, does it help you in your career?
I think it depends upon. So you're asking in the context of my UK qualification and my India
Right.
qualification, right?
Right. Right.
Yes. So see, one has to see their long-term objective of what they're going to eventually practice in, what they're going to do. So, for example, for me, someone like me who is always interested in disputes and who
Hmm.
always wanted to be affiliated with international disputes, having a foreign qualification serves well. So, when you have a qualification in more than one country, for example, since I'm qualified in UK as a solicitor, and I'm practicing advocate in India as well. So if we have a client at any given point in time who wants any representation in UK as well, then you have that at your disposal. You are qualified to represent in UK as well, right? So it all comes down to whether in which field you want to practice in,
Hmm.
whether your field of law involves people from across the countries, whether
Hmm.
you want to work in a field which involves people from more than one jurisdiction. If it does, and you see a lot of arbitration, which in arbitration field especially, there are a lot of crossing of paths between India and UK. You see a lot of
Right.
UK clients coming to India and India clients UK. So you see that if you want to work in arbitration and international disputes, you see that it is important at some point to have this
Hmm.
two qualifications. Dual qualification is something it becomes at some point extremely important. So in that sense, I think it is important for you to foresee how, in which field you're going to be working in, how it's going to serve you, and obviously there are always a plus side to having a second
Right. Of
qualification
course.
with you, and it's never going to be a downside of it. So
Of
because
course.
also, if I don't know, if also if you know, there's something called as DIFC, the Way International Financial Center. They also follow English common law.
Hmm.
So if you're qualified in UK, at some level you're also qualified to practice there,
Right.
and at some level you're also qualified to some extent in Australia as well, because
Hmm.
Australia also have English common law. So you see, you open avenues when you are qualified in more than one jurisdiction. So it's just about having your options available. If that thing comes to you, it should not struck you like that, oh, if I could have been foreign qualified, I would have done that. So being open to that and being foreseeing what you want to do in future, in that sense, I think having a dual qualification serves you well.
Yes. So it doesn't hurt.
It doesn't hurt. Definitely, it doesn't hurt.
Right.
Yes.
Can you tell some of the
Yes.
initiatives related to international arbitration that you're involved with?
Definitely. I think it's extremely important nowadays, and you definitely, you also know that being active in not just on LinkedIn, but also in the initiatives which are happening out
Right.
there in the field of law that you're practicing in is
Hmm.
extremely important. And at the end of the day, what are these initiatives? These initiatives help you to grow your network. They can help you bring your next big client. They can help you land your next big job. So it's extremely important to being involved in these initiatives. So what I have done is I've been involved with a handful of good initiatives which are actually going to make impact, not just in community, but to me as a personality as well. So first initiative that I've been involved is called as India VYAP. It's called as India Very Young Arbitration Practitioners. So India VYAP is a brand in itself. It's started with global VYAP. They thought that young arbitration practitioners need to have a platform to represent themselves because they're not getting enough space in the international arbitration community. So they start making these VYAP chapters in each country. And in India, I, along with two of my co-founders, have founded India VYAP. So I'm the co-founder of India VYAP. And soon we are going to be launching initiatives out of India VYAP and bringing young arbitration practitioners on board with either webinars or arbitration weeks, and making sure that their voices get heard in India, and they also get a platform to speak on and learn from each other and network from each other.
Right.
So that's one of the big initiatives that I'm involved in. And I don't know if you know that I have also been very specifically involved in writing projects. So I am one of the senior editors of Law Practice and Procedure of Arbitration in India. It's a book published by LexisNexis. It was released in January itself. So I'm the senior editor of that book. And so that's another project that I've been involved with. Apart from that, recently I was also selected as one of the mentees in Young ICCA. So Young ICCA is actually a younger network of International Council for Commercial Arbitration. It's a huge thing for someone who's interested in commercial arbitration. They have this Young ICCA group who organizes mentorship program every year, and they allow people to be part of this mentorship program. So whoever is a young lawyer, who's a young practitioner who wants to be mentored, who needs to know how to go about his career in international arbitration, he can take advice from someone who's at a partner level. So they connect partners of big law firms in the world, and they connect them with the mentees who are young practitioners, and then you can seek advice, you can organize events, and obviously you can carve your path ahead in arbitration field with the help of the advices and the insights of the partners who are already doing so well in arbitration community. So yes, that's a very brand new initiative that I'm being involved with, and it's a very competitive process. They get applications from around the world, so you have to be extremely good in your application to be selected as a mentee. And yes, I think those are the few handful initiatives in international arbitration and domestic arbitration that I've been involved with.
This is very brilliant initiatives that you are part of. Okay, one last question that I want to ask you. What are some of the insights or tips you can give to aspiring students who want to practice arbitration?
I think so it depends whether the person is seeking to work in international arbitration or whether the person is seeking on domestic arbitration. See, for domestic arbitration, there are a lot of uh, good young lawyers who are coming up, who are up and coming, who are working in the field of arbitration. I think it's extremely important that at an early stage, if you want to work in domestic arbitration, that you are associated with a person who's doing well in arbitration field. So you should do that. But before that, I think you should be very thorough with the law. Know your act inside out. being extremely thorough with the law is something that's going to pay you well in the long run in the field of arbitration. And then the third last thing is being thorough with the up and coming judgments. You see court every day pronouncing new judgments on arbitration,
Right.
and arbitration field is something which is evolving every day, and it is changing at a very rapid pace. So you have to make sure that you're keeping pace with the new judgments, with the new law which is coming out there with every new judgment. And once you do that, you know that you're up to date. You can help with your senior with any new case law. You can certainly just tell them that this is the case law that I had in mind, and you can help them. So doing these small tasks over a long period of time is something that is actually going to make you successful in the field of
Right.
arbitration. So it's
Right.
not something big that you have to do. It's just a small things, but very consistently over a long period of time, that is going to help you become really successful in the field of arbitration.
And writing applications to become mentees in some of these initiatives as well, right?
Yes, so
Participating in
depends. See,
these.
there are a
Yeah.
lot of mentorships. Yes, definitely. So see, you see a lot of mentorship programs happening. I see a lot of mentorship programs happening across the country and internationally as well. So see, it's extremely important for you to first see what exactly is the theme of the mentorship program. You have to see what you can take out of this mentorship program and what exactly is your objective for applying to that mentorship program. We see the mentorship program happening at a state level, for example, at a national level in India. You see a lot of mentorship programs happening, but what is their objective? What do you seek to gain out of it? That is something you have to filter first. Then you see the seniority at which they're taking mentees. For example, in young ICA, they hardly take students. They take only the young arbitration practitioners who are already into the field, so that they can help them carve their way into the arbitration field. So, but there are also mentorship programs in India I see that are for students, help them with their career building, help them with their CVs. So there are different steps of mentorship programs, different geographical regions of mentorship program, and then different seniority at which mentorship programs are happening, and not just nationally but internationally. So you have to see very carefully what you seek to gain out of that mentorship program, and then you have to also see that how is it going to help me? Is it going to further my objective, what I want to do through the mentorship program? If it does not, then I don't think so. It's viable for you to apply, put in your time making an applications. If it does, by all means, make sure that you make a very good application, apply for it, and then provide some insight to them about you, what you do, how good you are, how passionate you are about what they're doing. And if everything goes right, you will definitely be a mentee under the mentorship program.
Right. Thank you, Vishal sir. It was so informative to talk to you. I'll just stop the recording.